Good evening and welcome to the June 27th, 2024 meeting of the Walnut Creek Planning Commission. Will the secretary please take the roll?
Commissioner Kwok.
Here.
Commissioner Ward is absent. Commissioner Klopp.
Here.
Commissioner Reiser is absent. Commissioner Nating is absent. Vice Chair Anderson.
Here.
Chair Strongman.
Here. And do we have a quorum?
We do have a quorum. Thank you.
Thank you. Moving on to the item number 2, the consent calendar. We have one item of the consent calendar, which is the meetings of our meeting on the 13th. Do we have anyone who would like to poll it to discuss or make a motion to accept?
Make a motion to accept the consent calendar.
Second.
Will the secretary please take the roll?
Commissioner Klopp.
Yes.
Commissioner Ward is absent. Commissioner Klopp.
Approved.
Commissioner Reiser is absent. Commissioner Nating is absent. Vice Chair Anderson.
Yes.
Chair Strongman.
Yes.
Motion passes.
Thank you. Moving on to public communications, item 3. This is the portion of the meeting that is open to the public to make comments on any subject other than which is on the agenda. Therefore, would anybody like to come forward to make a comment? Seeing no one approach the podium, we will close public comments and move on to the next item, which is public hearings, the project of AB 2097 parking ordinance update.
Good evening. Oh, sorry. Good evening, Commissioners. My name is Henry Rood, Assistant Planner with the Public Works Department. You may remember 2 weeks ago we had a study session on some proposed updates to the zoning ordinance regarding parking. Today, it's coming back. We have a draft resolution which has been amended with some small fixes for your review, recommending a draft ordinance to the City Council. So just to kind of recap a bit about what is in this update, in response to our findings from the right-sizing parking study, we are lowering city parking minimums for residential. We are eliminating parking minimums within a half mile of transit as mandated by state law AB 2097. There are other updates for state law compliance. In addition, we're also changing how we regulate bicycle parking requirements to decouple them from automobile parking and adding new provisions for transportation demand management, in addition to some smaller housekeeping cleanup items. So the action item today, the Planning Commission is recommended to review the complete draft ordinance as amended and provide a recommendation to City Council for adoption. Staff recommend that the Planning Commission adopt this draft resolution, and then on July 23rd, City Council will review the ordinance for the first reading, and on August 6th, the second reading. So with that, if there are any questions or comments, I also have the slides from the study session as part of this presentation if you'd like to refer back to them.
Would anyone like to see those slides? Seeing no answer to that. Does anybody have questions? Any commissioner have questions for the staff? See, oh, go ahead. It looks like, oh, you have a hot mic. Seeing none, we will open up for public comments. Any member of the public who would like to comment on this item, please come forward. Seeing no one coming forward right now, I will close the public hearing on this item and bring it back to the commission for comments or a recommendation or motion to recommend to the City Council.
And does that motion include the changes as provided by staff?
That would include the recommendations. Those, I was referring to this sheet here. Is that correct?
Yes.
So it would be adopt the resolution and with those.
With those changes.
I move that we adopt the resolution with the changes that were made after the last meeting.
Second.
Thank you. Secretary, please call the roll.
Commissioner Kwok,
Yes.
Commissioner Ward is absent. Commissioner Klopp,
Yes.
Commissioner Reiser is absent. Commissioner Nating is absent. Vice Chair Anderson,
Yes.
Chair Strongman,
Yes,
motion passes.
thank you. And move on to item 5 of the agenda, the commission's consideration project, the updates to the design review project, progress and role of the design review commission. We'll have a staff report first.
Well, good evening, Chair and Commission. Ben Schuster with Community Development. If you'll recall, I was here a couple months ago now at a study session. We were talking, for the first time about all these changes to the zoning code, pages and pages, reflecting a new design review process, new objective standards, kind of various code cleanup. And that was all done at the behest of the city council, who provided direction last year and then kind of in previous years. So tonight, coming back to this body to kind of give a formal update of what the council did. It's substantially similar to what you all saw a few months ago. And then to kind of give you a sense of the remaining work that's left related to this overall effort, and then to provide you with a little deeper dive on the new process, what your new role will be, and then also to give you an opportunity to ask any questions. So again, tonight just going to touch briefly on the overall project, going to dive into what changed in the design review process, what's changed with the design review commission, going to touch briefly on objective standards, and then, like I mentioned earlier, open it up to question and answer. So back in May and June, just a couple weeks ago, the council at 2 different council meetings heard a number of things and took a number of actions. They adopted the residential and mixed-use design review standards and guidelines booklet. They also adopted a pretty extensive suite of municipal code amendments, and that, again, implemented new objective development standards for these residential mixed-use projects. Also updated our design review process, and that include revising the roles of the DRC, this body, the community development director, among others, and again, some minor code cleanups sprinkled throughout. So there's still a number of items that are ongoing related to this work. That includes the corresponding non-residential design review standards and guidelines. That work is anticipated to be brought to the council in September, and so this body would see that in August, along with corresponding changes to the zoning code for the non-residential development types. There's also some minor cleanups remaining to the DRC's roles and responsibilities that we're looking to delegate to other bodies as well, and so again, this body would hear those in August. So all of this work, why are we even doing it in the first place? 2 main reasons. One is state law. So state housing law over the past number of years has really emphasized the use of objective standards, actually requires the use of objective standards, as well as streamlining for certain residential development types. And then the city council kind of along the way has said we would love to streamline our overall design review process, have that kind of better align with state law and state intent. And so we've taken all that and kind of pushed through this huge body of work. So now I'm going to dive into what's changed in the design review process. Again, this should all seem pretty familiar to you. Not much of this changed when the council adopted it. So kind of the key highlights here is the Design Review Commission formerly was the approving authority for essentially all design review entitlements in the city. that has been taken away and been given to either city staff, that's the community development director, or to this body, the planning commission. And we'll talk a little bit more about that. And it also established, like I mentioned, new processes for all the the kind of variety of state housing developments. And we've, again, codified that and clarified that. So those are kind of the main takeaways from what changed process-wise. And then as part of that, we also, again, revised or redelegated all the kind of miscellaneous duties of the Design Review Commission in keeping with the council's direction. And so you can kind of see on this list, there's just a lot of miscellaneous things that the DRC over the years had approval authority for. And so those are being removed and given to other bodies. The two at the end marked pending, those are items that staff is currently working on. And like I mentioned, those will be included in August when we come back to this body. So here I've highlighted the Planning Commission. So you can see on the left, existing, well, no longer existing, but the old role and then proposed is now actually adopted. But essentially the key takeaway here is the Planning Commission goes from a body that would hear appeals of design review entitlements to now being the authority that acts upon our large design review projects. And so what's a large project, what's a small project? We call those minor and major. So minor projects, these are all, for the most part, done at the staff level. And these are, 4 residential units, essentially small additions, kind of minor commercial storefront updates. So, a new store comes into Broadway Plaza, new signage, new storefront, that's all done at the staff level typically. And then anything that's not specifically codified now in the design review article, that would then be approved by the Planning Commission, with the Design Review Commission serving as an advisory body to this commission. So there's 3 new types of design review categories now, and again, this should all sound pretty familiar. Ministerial, again, this is staff level approval regardless of the project size, and that's because of state law, which mandates these decisions be made without a public hearing. And so the Planning Commission will never see these projects. Objective design review, this encompasses, again, other types of state law. Really, it's essentially we're treating it as all residential projects in the city or residential mixed use projects. There's state law establishes a meeting limit. There's also limited discretion by the city to deny. And so really it's, if a project complies with all objective standards, the city essentially must approve. And then the last one is discretionary design review. Again, this kind of matches what we do today. This will apply to all of our, well, I should say continue to apply to all of our commercial projects in the city. And then it will also apply to any residential projects that, for one reason or the other, opt out of objective design review. And so with these different pathways, there's then kind of 2 approval pathways. I'm only going to focus on the ones that are relevant to this body, so that's objective and discretionary. So there are kind of rare circumstances where the Planning Commission might hear a small project normally delegated to staff, and that would only be in the scenario that there is an associated entitlement that the Planning Commission already hears, and it's associated with a small design review project. This is, I would say, the great exception and not the rule, and so this will very rarely happen. But for major projects, the process will always be the design review commission gets a singular public meeting. It's a study session. They will provide their comments and recommendations to the Planning Commission, and then the Planning Commission would hold a public hearing to make a final determination on the project. Discretionary design review is the exact same approval kind of pathways. So everything I just said for objective, that would apply here for discretionary design review as well. And as I mentioned earlier, objective design review projects essentially must be approved if they comply with all applicable objective criteria, including our objective design standards and our objective development standards in the zoning code. And there is very narrow grounds for denial. Those grounds for denial are actually specified in the state law and are usually based in, I believe, health and safety. Very limited. And then discretionary design review, again, is what we do today. Design review is a kind of subjective entitlement. We, as a city, may approve, may deny, may approve with conditions. Wide discretion to approve or deny. Okay, so I'm gonna pause there on the design review process and then jump just briefly into objective standards. What makes a standard objective? And really it's kind of these three definitions here on your screen. There's no personal or subjective judgment involved. It's uniformly verifiable and measurable, and then it's known to all parties prior to submittal of an application. So really it's about essentially the free flow of information, right? Everyone has the same set of information up front, and a developer can know if my project meets all of these requirements, my project will be approved. And objective standards are, again, located in our now revised and adopted residential design review standards and guidelines, and then also in the zoning code. The form of them, or the intent of them, is a little bit different. So the standards in the zoning code, those are probably familiar to you, things like height, setbacks, lot coverage. So they kind of help define the overall mass of the building on the site. And then the design review standards and guidelines, those are all about how do you actually implement that. So building articulation, specific landscape materials, and the like. So the design review standards and guidelines booklet, and again, this will also apply to our non-residential booklet when it's adopted. They're formatted in essentially the same way. There's a bunch of chapters. Each chapter has an intent statement that says, you know, the intent of this chapter is to accomplish X, Y, Z. And then there are standards listed. And standards are things that a project must comply with. And then there are guidelines. And guidelines are things that they were not possible to make into an objective standard. For example, you can't measure paint color, as an example. And so guidelines are strongly recommended, but for projects protected under state housing law, they do not have to comply if they choose not to. However, for projects going through a discretionary design review process, we do have a lot more authority to enforce both the standards and the guidelines. Okay, so kind of putting it all together, we have our new process and we have our new standards. So what does this mean? So this slide, and then we're going to go into each one, kind of gives you the high-level overview of the majority of the projects that this commission will see, which are, again, the larger major projects. And there's really 4 steps that we're going to walk through. So a project comes in, is submitted to the community development department, so a staff member intakes the project. We then do sort of an initial analysis, determine if a application is complete, incomplete, and then we make a determination on the compliance with objective standards. And then we write a staff report. And that staff report is then part of the overall packet that goes to the Design Review Commission for the DRC to comment on. And the Design Review Commission's role is, again, to look at staff's analysis, to then look at the project through their own set of, kind of their own lens as design professionals, and then to make their recommendation and comments on the project. And then they make a recommendation to the Planning Commission. then the project effectively goes back to staff to summarize the DRC's comments, to kind of write another staff report, summarizing everything, and then coming forth to this body and making a recommendation to the Planning Commission for an action. And then the Planning Commission, which is everyone here, you'll have all that information, you'll have all of staff's analysis, the Design Review Commission's analysis, you'll hold the public hearing, and then you'll take action on the project. And here I just really wanted to emphasize, this is a new process for all of us, for staff and for all our various commissions. And so we're all kind of in this together, and just because it's new doesn't have to be scary. And so we'll support each other through this new process moving forward. So with that, like I said, I'm available for questions on anything I covered tonight, and that concludes my presentation. Thank you.
Thank you for your presentation. I have a first question for you is, what decision are you hoping for us to make tonight?
There is no action required for you. This is just an update
Okay,
and an
thank you.
opportunity for you to ask any questions about the process.
Okay, thank you. Other commissioners?
All right, thank you for the presentation. I do appreciate all of the staff's work on the consistency, preparing the materials and everything for us to review, as well as all the other commissioners and the city council. I did want to clarify, so I know you talked about the classifications of the minor projects versus major projects. If they are major, are they always going to pass through design review
Yes.
commission? Okay.
Yes, and that was by design. That was specific city council direction. Yeah.
And then when the design review commission makes a recommendation, is their recommendation going to be a separate attachment as part of the materials that we'll be getting for our consideration?
I think that's something as a staff we're still working through. It's not going to be
We don't anticipate that the DRC would have a resolution
Oh,
or
I see.
anything
Thank you.
like that.
Yes.
It would most likely be just something in a staff report.
Okay, cool. All right, thank you.
Commissioner Anderson?
Thank you. A couple of questions. The way it's described there, with the objective standards, it's just, does it or doesn't it?
Yes.
Check the box.
Yes.
Having sat through my share of design review meetings and know how designers like to discuss things, checking the box isn't really kind of the way they do things, but that's the process. It's the process. I'm wondering, is there, it sounds like there's nothing for them to decide in a sense, because it's sort of there. But even with an objective standard, there's inevitably going to be some ambiguity, some play in the way the words are constructed, and just an interpretation of how a particular design complies or doesn't comply with it. Is there some, I'll just call it flexibility. There's some flexibility that design review has to say, we don't think, maybe the staff does or maybe the staff doesn't, but we don't think that what the designer has brought to us as complying actually does. So, is there at least that much discretion that they have? I hesitate to use that word, but yeah.
Yeah, so I think there's a couple different pieces to your question. Let me see if I can work through all of them. Again, I kind of go back, first of all, to the definition of what an objective standard is, and really it is intended to be clear and unambiguous.
Yeah.
And so that was very intentional in the development of the standards and guidelines document. 2 members of the DRC were actually heavily involved as part of the city working group in developing those standards. And so really, there really should not be any ambiguity. There is some flexibility built into some of the design standards in that there are multiple ways to meet a certain standard. And so that's baked into the document directly. Kind of the third piece of that is there is always an ability and an option for staff and for the design review commission and for this body to provide their comments and thoughts on a project to the applicant. However, the applicant is only required to follow the kind of strict, compliance with standards. And so I think there will be opportunities, with certain developers who wish to be good neighbors and good partners, right, to listen and hear the feedback, especially from our design professionals. But the actions that are taken by this body to approve really can't consider that. So if the developer ultimately says, I don't want to do that, then really we still have to kind of comply with state legislation.
And kind of building on that, I'd like to kind of get a good sense of how the meeting limit comes into play. So the state limit is 5 meetings per project, correct?
Yes, and again, just to emphasize, we're talking about residential projects.
Okay.
Yeah.
So you're allowed 5 meetings. Now, if a project is pretty approvable and goes through a short path, would that be meeting at the design review? Okay, it's one meeting. They make a recommendation to the planning commission. Planning commission takes the recommendation, says, yeah, that's right, approved, and then project is approved. There's no other meetings likely to happen.
Correct. Okay. And so the 5 meeting limit really is intended to limit the number of, for example, continuations, that a body can do. It also includes the, if you think about meetings for appeals, for example, that would be considered another meeting.
Next question was, so say they appeal
Yes.
to the council, I guess.
Yep.
That would be a 3rd meeting? Or
Yes,
is an appeal
that's
separate
correct.
deal?
The appeal counts towards that 5. And just to clarify that the 5, it's not 5 hearings, it's 5 meetings. And so as I understand, that can be, for example, if the city mandated the project go into a a community meeting, that would actually count as a meeting as well.
Okay. So I know I've some design review, before there's actually an application, they'll do a kind of study session, sort of a sit down with the developer and just kind of, throw ideas back and forth. And that may change, some of the things that they, do, partly because they're good ideas, partly because they might be, more likely to get a good recommendation or approval. What concerns me about, in particular, the 1 meeting limit for the design review is, and especially, if you're only just interpreting objective standards, then there's never no ambiguity, but, limited ambiguity involved. That the value of design review is really kind of lost there because, design review doesn't see the thing until they come in for their study session. And they've only got that 1 meeting to say, recommend yes or no, and they can make some specific suggestions and recommendations that we might, implement or something, or that the applicant might implement in order to get an approval from us. But, with a single meeting, there's really no give and take there. So what I'm wondering is, a couple of things, and, sort of like after the fact, I suppose, but it's, I think, important to get this idea out there. If there were to be, say, an informal get-together with design review members and the applicants, before any application is made, or before it goes for an official hearing, I think that there's 2 ways that might go, and I think I know how it would be interpreted. I assume that if the whole design review group gets together with, you know, the applicant and the designers, and they sit around and do a little charrette and, you know, have fun for an afternoon, that even if that's not a noticed official, well, probably would have to be noticed, it's a quorum, but that would count as a meeting. Am I correct?
I'll let our
If no application has yet been made,
city attorney weigh in on that.
So if no applications come in, so first of all, you're correct that there is the Brown Act issue. You really couldn't have
right,
a quorum of the commission meet like that. But if the application hasn't come in and it's the developer kind of, you know, the applicant comes to the city, approaches the city and says, this is what I'm looking to do, what's your feedback? I don't think that would count towards the meeting because the limit is really imposed when you have your complete application once it comes in. So if it's like, hey, before my project, I want to understand what's the city's position, what's, you know, what you're looking for. I don't think that would necessarily count. That wouldn't count as a meeting, but then you couldn't do it in that format with the, you know, with the majority of the members meeting that way.
okay. And I was going to say the other option would be to, you know, have the applicant just, you know, informally seek advice from, say, 2 of the 5 members, you know, individually or perhaps 2 together, but, you know, just get some feedback. So if there were the possibility that design review could, there were not a 1 meeting limit on DRC, that they were allowed 2 meetings, okay? How would that impact the ability of the city to limit it to 5 meetings?
So I think to start, you know, one of the reasons why we implemented a 1 meeting limit was at the kind of direction of the city council, who specifically asked for that, which is why we incorporated it.
We don't mind blaming things on the city council, that's fine.
But to kind of your point, if the DRC were allowed to have 2 meetings, then again, thinking about, you know, the action, right, the approval or denial of a project by the planning commission at a minimum is 1 meeting, and then you have to hold essentially space for 1 additional meeting in case the project is appealed. So now we're talking about 4. So that means at most the planning commission would need to make a decision in 2 meetings.
In addition, part of the reason for the design review authority changes is to make sure that the process is expedited, so that even though we can have 5 meetings, that's not necessarily what we want to do as a city.
So, sort of the same idea, what has been your feedback from the Design Review Commission on well, both the limitation as to what they're allowed to do in terms of decisions, and the fact that they're now only an advisory board, and they only get 1 meeting?
I think that would probably best come from the secretary, so I'll let him chime in.
So just to inform the Plan Commission, 2 members of the Design Review Commission has resigned, so there are 3 left. So part of it is, I think they didn't feel that they had the authority to make decisions anymore, and so they felt that they thought they wanted to resign.
Okay.
And you know, it's really to add to that, it's a change that the city's going to have to adapt to sooner or later, and because of the trends in the state legislations, and so this is an effort in trying to move the city towards that, and trying to, you know, there are some developers that will argue objective design review means it's like ministerial. You don't do anything, you just approve it. And so we're trying to not go that route, but also like preserve that room for the cities to still say, hey, this is what we think the design should look like, but also abiding by the objective criteria that it's supposed to, you know, it's supposed to abide by. So I think that's, it's a change. That's not, it's not the way that the city is used to conduct things, but it's a direction that, that the city as a whole is trying to move to adapt to the changes in state law, because that trend is going to continue at the state level.
So,
One quick clarifying question. I recall in the presentations done when we started talking about this, a comparison across cities of which cities have a design or architectural review committee and which don't. So it's, or commission, and it's not consistent, right? So other cities have been able to manage without one, or how do they do that?
Yes, there are many cities that just rely on a planning commission and don't have a design review commission.
yeah, I know Oakley has a youth commission and a city council. That's it. Yeah.
Thank you.
So, coming to the planning commission now, we get a recommendation. Presumably, it's based on the design review people who know the, their stuff inside and out, and they said, this complies with the objective standard, or it doesn't. Are we then in a position to look at those decisions and see if we agree with them, and or because it's subjective, and are we sort of not bound by it, but sort of impelled by their decision and their expertise to accept that?
Sure, that's a great question. I think it's a little bit of both. Again, when staff will always be the first eyes on a project. And again, because of the nature of objective standards, that they are clear and unambiguous, it becomes easier to essentially go through a giant checklist that is provided to the developers and then checked by staff. So we ask developers, does your project comply with the landscaping standard? And they will say yes or no, or not applicable. And then they will tell us, you will find our landscaping calculations on sheet whatever of our plans. And so then staff is essentially going through and checking, yes, we agree that you meet the city's landscaping standard. The DRC, in that capacity, again, we're talking about objective design review. This is only for residential projects, so the commercial stuff is a little bit different. They're essentially doing a second check and going through and doing the exact same thing, right? And then when it comes to the Planning Commission, you will have two sets of staff and the design review saying, yes, we believe this project complies, or no, we don't. And then essentially you are the final check, so to speak. But you will again have a lot of previous analysis done for you, and so that whatever you land on your decision, it's probably going to be in the same vein as the previous analysis done, right? But again, we really do not have a lot of flexibility, right? And so it's if you comply, we have to approve.
And just to add to that a little bit, so state law actually also has a standard about what it means to be consistent with an objective standard. So if a reasonable person can say that it complies, then it's you're supposed to say that it's compliant. So if you're
Assume design review is reasonable.
right,
Okay.
so a reasonable person, it's kind of the standard that kind of lawyers like to use. But so if you have that standard, and so if you had some comments from the DRC or even from staff, and I'm not a designer or a planner, so I can't try to give you an example, but if you had something like that, it's down to 1 to 2 standards, and that's before the planning commission. Then we're going to look at that and we're going to say, well, is there some reasonable person component to say like they do comply with the standard, or is it so it's pretty obvious that it's off, or is it pretty obvious it's not compliant? Then that would come into play.
So, so just in terms of the path of the application, let's say the design review sends it to us with a recommendation that it doesn't comply. There's a few things here that we think they just overstepped it, or they just did the calculation wrong, or whatever it may be. But we think they don't comply. We take that and we agree and we deny it. They appeal to the city council, and the city council, let's say the city council agrees with us, okay, and deny it. Then that's done, right?
Correct.
Correct. If the city council disagrees and said, no, it should be, again, is that the end of it, or does it doesn't come back to us or to the design review?
It does not come back.
Okay. All right. Yeah, and if our decision doesn't agree with the recommendation we get from the design review, the same thing, they can, they or the neighborhood can appeal it, but it's not going back.
That's correct.
Okay. I think I'm done. Thank you.
Any other questions right now?
Yeah, I had a quick, thank you again for all this work and for taking time for us to talk it through with you. I had a quick question about the transition process and managing when applicants who are in the pipeline are going through it, how it's gonna work.
Yeah, really great question. That's obviously a discussion we had to have with our city attorney, and I'll let her chime in if I am missing anything. So the new process, the new standards, that was all adopted on June 4th by the council, and so that goes into effect 30 days later, so July 5th, essentially, which is a Friday. So Monday the 8th, is probably the earliest reasonable time we're going to get anything new. But any new applications that come in after that time will be evaluated against the new standards and will be processed through the new kind of framework that we've established. So that's pretty simple. For projects that are kind of in the pipeline, so to speak, there's really, if you are a project that is deemed complete, and so you've submitted an application and staff has made that determination that we have everything in your application needed to evaluate your project, and that the date of that letter is before July 4th or 5th, then the standards used to evaluate the project would be whatever the standards were in place at the time. And so there will be a couple projects that come through that we will evaluate against and the previous set of standards. However, the process for those old projects will more than likely be the new process. And the reason for that is the new process is more clear and kind of more straightforward than our old process. And so state law allows us to apply the new process so long as it isn't more onerous, or yes, more onerous than the old process, and in our case, it isn't, so.
And we don't anticipate that there'll be very many projects that will be kind of stuck in that transition.
Okay, thank you. I just have one question that occurred to me is when the developer does not meet one of the objective standards, what happens throughout the process?
Yeah, great question. So there's a couple options. Actually, we were having a pretty deep discussion about that earlier today. So kind of to get into some of the inner workings that you typically don't see. So when a project comes into the city, there's a planning application form, and there's all these requirements on there, including what we're developing right now, which is essentially a compliance checklist with objective standards. And so staff during that initial 30-day review period are looking at the application and saying, did your project submittal provide all the things that we asked you for? And then within that letter, we're also kind of evaluating, does your project look like it meets all the objective standards? And so in your example, let's say we as staff think, hey, it looks like you're not meeting two of the standards that we would require to be able to approve your project. So at that point, the developer really has two options. Three options, actually. So one is they can revise the project, and we would advise them of their options in this letter, so they can revise the project to essentially come into and show compliance with the standards. That's option one. Option two is they can basically waive their kind of streamlining rights under state housing law, and we would process them as a discretionary entitlement. In that pathway, I mentioned standards and guidelines earlier, so under that, there is a lot more leeway for staff, the DRC, for the Planning Commission to have that kind of give and take that you were talking about earlier. And so we would go through that process. And then the final pathway is the developer disagrees with staff's assessment, and they say, no, we would like you to continue processing the application. And if we don't receive any new information that influences our decision, and again, it would go to the DRC for the second and then Planning Commission for that third and final check, then ultimately the outcome would be a denial of the project.
Thank you, and one more question over here.
So would it be possible, let's say that it came to us in your example with the recommendation that there's two objective standards that were not met. The floor area ratio is calculated wrong, and it's actually 2% too big. Something else. Could we then, despite the fact we're dealing with objective standards, but in fact with an interpretation of the objective standards perhaps, we have a choice of denying it because it doesn't comply, in which case they're going to go back, they can appeal, and then they lose that, and they have to go back and start all over again. Or approving with a stipulation that they remove, 2% of the floor area on a revision that the staff can confirm. Is that one way to deal with that kind of situation? If we think, in fact, there's non-compliance, but we want to, allow them an option to resolve it without going back to the beginning.
So if I can kind of repeat that back, I think
Sure.
what you're asking for is, can we condition a project to meet certain standards that they're not meeting, and then approve that so long as they do X, Y, Z?
Yeah.
I'm going to let our city attorney weigh in on that one. Thank you.
Yeah, so the commission would have that authority, that you would have the ability to condition the project, because the whole premise of why we're doing this is that state law requires, if the project complies with all the objective standards, you have to approve it unless you make the findings of adverse impacts based on existing standards. So if the project is not compliant with the objective standards, that structure goes away. And so essentially you're reviewing the project as in the beginning that you would. You're saying, you don't comply. Here are the conditions. We're not required to make findings. And the findings I'm referring to earlier it's for denial and also for lowering the density of the project, which is anything that reduces the ability to provide housing. So if they don't comply, that protection really goes away, and you can say, well, you don't comply, so here are the conditions, and even if the conditions somehow reduces your density, it's within the city's ability to do that because you do not comply with the objective standards. So yes, you do have that ability to impose conditions.
And part of part of the public hearing is really having that discussion with the applicant if they're willing to make the changes. So for example, if they come in with an application and half of the objective design standards are not met, that may be a point where, there's not going to be a whole lot of discussion and it may be a clear answer. But if there's like certain things here and there where they can make some adjustments, where they can meet the standards, and so, that's sort of the purpose of the public hearing. But the point of it is to make sure that they are getting to the point where all the objective design standards are met.
Thank you.
Thank you. And just, any more questions? Do we need a public hearing for this item?
It's not a public hearing, and I don't see anyone in the
And
public.
that's true, very true here. Therefore, we will not have a public hearing. We see there's no public in the room. Do you have what you need from us?
Yes, again, this was just, an opportunity to clarify any questions you had, and
Thank you for all of your hard work on this.
thank you.
And we'll move on to commission member or staff reports or announcements.
No reports by staff, thank you.
Any from the commission? Seeing none, we will now be adjourned to item 7. Thank you for coming.